Okay, so ready?
Yeah, ready when you are.
I think then I should be here for a moment.
Yeah.
So that I can give
Well, I go this side.
the introduction.
Kurz einen Augenblick, kurz, dass das Signal auch wirklich angekommen ist. Okay, los geht's.
Hello everyone, welcome to Law After Lunch, also in the name of Professor Tietje. I welcome you to another session. Today we have here as our guest from the University of Aberdeen, Malcolm Combe, who is a senior lecturer at the Law School of the University of Aberdeen, and a dear colleague whom I have met during my time back in Aberdeen a couple of years ago, and it's a great pleasure that we managed to bring him over to Halle to give a talk to us today on the issue of land reform in Scotland, including an outlook on sustainability, which might be very interesting to us also as from the German perspective, also looking at issues such as climate change, etc. So I think it's important to learn how land use can be changed, how land reforms can help. That will be one aspect, but there's going to be many more in his talk. Malcolm Combe has worked as a solicitor before joining the law school, so he brings the practical element, and that also expresses itself in the fact that he also is interested in clinical legal education. Apart from it, his research interests are property law and commercial law, and I think currently in particular the private regulation of land use, abandonment of land, and land reform issues like the one he's talking about to us today. So thank you very much, Malcolm, for joining us, and I'm really looking forward to your talk.
Thank you. Okay, thank you very much, Professor Hanschel. Thanks everyone for coming along today. I'm conscious that I do have quite a strong accent, so I will try to keep the tempo down a little bit, and if you do have any questions, feel free to ask at any time. But without further ado, let's get on with my presentation, Land Reform in Scotland, which prompts two questions. What do we mean by land reform? And then the second, more subtle question is what do we mean by Scotland? And just for a bit of a laugh to start with, this was the advert that went up for this talk, and I put this on my own personal Facebook page, and someone from the Orkney and Shetland Isles, which are up here, the Northern Isles, replied to say, "Where's Orkney and Shetland?" So that he redid the map. He did to say, right, this is the more important bits. And if anyone's interested, down there, that's where Scapa is. Scapa Flow is actually where, to go into the history, about 100 years ago, the German fleet ended up in Scapa Flow. And also, but more topically and more friendlily, I brought a nice bottle of Scapa whiskey over to Professor Dirk Hanschel for this trip. So if anyone wants to hang around Dirk a little bit later, you might get a nice drink of whiskey from him. What do we mean by land reform then? This was the definition that was put forward in something called the Land Reform Review Group, which was a government-appointed group which was set up in 2012 and then reported 2 years later. I was latterly an advisor to that group. I didn't actually have input to the definition that they came up with for land reform, but what they said was measures that modify or change the arrangements governing the possession and use of land in Scotland. Interestingly, in that definition, they say nothing about ownership. They say possession and use. Now, maybe they were thinking of possession, which in the English translation of Article 1 of the First Protocol of the European Convention on Human Rights, there is talk of protecting possessions rather than protecting ownership. But as we will see, a lot of the land reform movement in Scotland has been about changing who the owner is, as opposed to just changing what happens with the use of land. So, broadly, you can define land reform in two sort of fairly crude ways, two fairly simple ways. It might be something which is reform for all landowners. And the picture here is a picture I took, which is in the outskirts of Perth, one of the cities in central Scotland. And that's a sort of old castle. I say it's old, it's a faux castle. It wasn't actually a defensive fortification. But this is a famous castle in Scots law circles because there was a case to do with a new right of access to the outdoors, what in in Norway would be called the friluftsliv, or in Sweden would be the Allemansrätt, the right to roam, the right to go into the outdoors. And there was a famous case there as a result of our Land Reform Scotland Act 2003, which gave everyone recreational, educational and certain other rights to go onto land owned by other people without necessarily having prior permission. So that was a reform that changed regulation of land for every owner. It didn't matter who owned, you would all be subject to this new regime. Or the other way we might mean, sorry, I went a little bit too far with my clicker there. The other type of land reform would be reform that's designed to change who the landowner is. And why might a jurisdiction do that? Why might a jurisdiction think about doing that? And specifically, why might Scotland think about doing that now in the modern era, given that we're a fairly mature legal system? You would have thought land reform might have been a thing of the past for the UK, but Scotland perhaps shows that it's a topical issue to engage with just now. In terms of the historical reasons for land reform, a few hundred years before, there have been episodes of the so-called Highland clearances, or even the Lowland clearances in other bits of Scotland. I'll show you a map of Scotland in a moment so I can differentiate the areas for you. This was a time of so-called improvement, where traditional inhabitants of land who maybe didn't have a formal lease arrangement were, shall we say, encouraged to leave traditional areas, and they were then depopulated, and there might be, or certainly at the time in the 19th century when this was coming to a head, there was a drive by the people who had been affected to try and get some of their land back. And then another historical reason, and this is actually what I'm about to refer to, is the name of a play which was quite big in the 80s in Scotland, called The Cheviot, the Stag and the Black Oil, which was presented by a theatre group called the 784 Theatre Group. The reason it was called 784 was because at that time there was a perception that 7% of the people controlled 84% of the wealth in the United Kingdom. And these sort of commodities that are mentioned here, the Cheviot, the Stag and the Black Oil, these were all commodities that were essentially preferred to the traditional inhabitants of particularly the Highlands. The Cheviot being a type of sheep, the Stag, that we'll see a picture of a stag later, the sort of iconic red deer in the Highlands for Victorian blood sports, that these sort of ended up being prioritised over more traditional uses of land. And then the Black Oil, where I am at the moment, Aberdeen, is seen as the sort of one of the main centres of the North Sea oil and gas industry. So there has historically been reasons where uses of land have maybe pressed against the traditional interests of who would have been seen as the inhabitants there. So I could go way into the history. I'll just take this year, 1886, as a semi-arbitrary starting point for history. In 1886, there was something called the Crofters Holdings Scotland Act passed, and that was really the first British attempt for land reform, which tried to address some of the issues that were going on in Highland Scotland at the time, and that's the sort of dark blue area there. And they introduced land reforms which mirrored actually what was happening in Ireland, which at that time was still part of the United Kingdom, giving people who had informal rights of occupancy, people who were still hanging on bits of land, the right to stay there, security of tenure, a right to fair rent, and a right for compensation for improvements. Anything that they put on the land, they couldn't just be kicked off and not get compensation for that. And also importantly, these leases could be passed onto family, or when the area became vacant, it would still be subjected to these controls. And these controls were very important in terms of keeping populations in the Highlands of Scotland. And there you can see Orkney and Shetland again in this map. Not forgotten about them at all there. So I'm not going to talk much about the crofting system, but it has historically been an important reason why populations have stayed in the more fragile areas of Scotland, and it features in contemporary land reform as well in terms of some of our community rights to buy, which I'll come on to in a moment. So that's the historical stuff. Let's fast forward now to the present day and point out that in Scotland we've not been engaging in land reform for any reasons particularly related to restitution, which you might see in jurisdictions like South Africa, or indeed you might see in the jurisdiction in East Germany, where you will know more about than I do. There has been a need to sort of find owners who have been historically wronged and give back, or at least give them a chance to stake a claim in relation to assets which were taken away from them wrongfully. Then also in some jurisdictions there is a drive to give people land for subsistence agriculture, and this might be associated with some of the landless movements in South America, for example. They haven't really featured in contemporary debates about land reform in Scotland. What has featured is ideas about community retention in more fragile areas, and indeed revitalisation of communities, allowing for local enterprise. A fear perhaps, and that ties in with my second bottom bullet there, the idea of monopolies might be an issue. If you've got one landowner in Scotland that controls a large area, and we'll look at some of the proportions shortly, that might be seen as something that would stifle and prevent development happening. The simple idea of social justice, and then also possibly the idea of better serving the environment by allowing local people to make local solutions. And the reference there is a paper I had in the Environmental Law Review, a UK journal last year, about how redistributive land reform might play a role in reducing or mitigating some of the land choices that might otherwise have happened if you didn't have a local element of involvement. In terms of why this matters for Scotland, just a quick geography lesson, and I'm not a geographer, so I'm probably going to grossly simplify things. I've taken this map from the James Hutton Institute, which is a scientific research institute that has a place in Aberdeen and a place in Dundee down there, both on the east coast. And in terms of the green areas of Scotland, particularly down the sort of yellowy green areas, they are the sort of more arable bits of Scotland. They are the bits that you can farm as much as you possibly can, and it's pretty much in Scotland's national interest, given how rocky and upland some of the other areas are, that these areas need to be farmed as much as possible. So changing who the owner is in relation to that land probably won't actually change very much in a strange way, because it's always going to be in the national interest of Scotland in terms of its food security to farm these areas as much as it can. It's more in the other areas, the more fragile areas, where the owner choices might make quite a big difference, and we'll come to the rights that ownership gives shortly. Thinking about the concentration of ownership, this figure here, 43250, this has become a real sort of totem of the current land reform movement, and it was featured in various parliamentary reports, both at Westminster and Westminster being the UK Parliament, Holyrood being the Scottish Parliament. Both parliaments sort of picked up on this, and that figure is strongly linked to the research of a campaigner called Andy Whiteman, who's now an MSP, who's now a member of the Scottish Parliament. And that figure denotes the fact that in his calculations, 50 entities, or rather, no, I've got that the wrong way around, 432 entities or individuals own 50% of the privately owned rural land in Scotland. Now, Scotland is a country of about 5 million people, so if 500 odd people control all that land, that's quite concentrated. There are a couple of key caveats there. Privately owned, so I'm not talking about land that's in public sector ownership, like forestry land or Ministry of Defence land or anything like that. And I'm also talking about rural land as opposed to urban land. But it's a key point in terms of concentration. There's an ongoing argument about how accurate these figures are, and we're trying to improve the transparency and accessibility of our land registers to make that information clearer. But notwithstanding how clear it is, some of the sort of economists might look at that figure and go, what's the problem? Where's the market failure? Particularly given some of Scotland is quite fragile, and to make an estate in Scotland work, you've maybe got to have an economy of scale where you've got more useful land being owned with slightly less fertile land, and then that way you can make it work. So it's an interesting question. There's lots of ongoing research about that, and there's a link there at the bottom to some of the Scottish Government commissioned research on what role a landowner has in this arrangement, and the extent to which a landowner does have a role might play into drives for possible reform in future. Another ongoing debate that features is the idea of what's more important in relation to land. Is it use or is it ownership? It's kind of mixed together though, and I'm sure I switched into Latin because I thought people who know about Sachenrecht here will be familiar with these terms. Dominium, usus, fructus, and abusus. If you have ownership, you can use the item, you're entitled to the fruits of it, and you're entitled to consume it as well. And so property rights are pretty important in terms of agenda setting, in terms of what happens with land. So changing who the owner is a key part of land reform for many, many jurisdictions, and it seems to be at the moment, it's the case in Scotland as well. And admittedly now in the modern era, conservation laws will stop some of the bigger excesses of landowner choices in the 19th century when people were moving towards a very sort of sheep-oriented economy in the Highlands. They would be busy killing eagles or polecats or things that were seen as against the interests of the shepherds to look after the animals. Now conservation laws would stop some of that happen. But ownership choices can still play a big part in terms of how many deer are killed by any given area, how many deer are killed in a given area, because landowners can choose. It's a prerogative that runs with the land who can shoot a deer, and that's something that's an ongoing bit of research in Scotland. And one of the more recent things I've been involved in is a working group looking at deer management in Scotland, and I'm an external advisor to it. So if anyone wants to tell me about what's happening about deer management in Germany, please speak to me later on. I'd be very keen to hear from you. Okay, so that's enough background. Now we'll actually talk about some law. Since I'm in a law school, I thought I'd better try and do that. The key reform dates for Scottish legislation about land are 2003, 2015 and 2016, all of which happened after devolution, which rather begs a question, what do you mean by devolution, Malcolm? Good question, I'm glad you asked. So that dictates a little bit, or rather necessitates a bit of knowledge about what the constitutional setup of Scotland is. Scotland is in a union with the United Kingdom, so England, Wales, Northern Ireland, and is also in the European Union for the moment after the Brexit vote in the 23rd of June 2016. We might be talking about that a little bit later today, so I'll say no more about that just now. We'll see what the Brexit vote means for the other union as well. It's all very much a live issue, but there was a very interesting debate in the UK Parliament last night about how much Parliament needs to approve the final withdrawal settlement, and it now seems Parliament does need to approve, so that's some nice current topical constitutional matters, but I could talk about that all day and I won't. But why am I talking about the two different setups of the UK and European Union setup? Well, UK legislation established this new Scottish Parliament at Holyrood. There's a hopefully bonny picture of the Scottish Parliament there. And it's not federal, it's a unitary state, but the Scottish Parliament can pass so-called devolved legislation within the parameters of the Scotland Act 1998. And by that I mean it's not allowed to legislate outside of its legislative competence. It's got a defined, truncated legislative sphere of influence in terms of the Scotland Act 1998, and things that are specifically reserved to Westminster, the UK Parliament, or things that don't comply with the European Convention on Human Rights, or indeed EU law, cannot be legislated on by the Scottish Parliament. Property law is not reserved, so the Scottish Parliament can do what it wants when it comes to its property law, but it's still controlled in relation to the ECHR and EU controls. The other key point about devolution is the Scottish Parliament has had a bit more time to look at issues of Scottish concern in a way that the busier UK Parliament didn't. So things like land law that hadn't really been looked at before 1998, suddenly we've got a Parliament that's had the time and the inclination to look at Scottish land law. So that's why we've had the legislation that we've had. In relation to Scotland and the European Union, I should say that EU law has not been hugely relevant to land issues in Scotland, but it has been important in relation to, for example, if a local authority has wanted to do something with land to the benefit of individuals in the local community. They have to think about procurement rules and state aid rules. Also, in rural land matters, the EU has been pretty important for agricultural support. And also in relation to regulation of free movement of capital. So if Scotland was to try and restrict who was allowed to own land in a way that would stop free movement of capital across the EU, the Commission would get very interested, I'm sure. So the Brexit might change some of this. We just need to wait and see. Human rights concerns. There are maybe 3 key areas that are important for a property lawyer looking at land reform. You've got the issue of people being entitled to a home, Article 8. You've got fair hearing provisions in terms of Article 6. You can't just interfere with people's property rights without giving them a chance to be involved in the process. And also you've got the right to property in terms of Article 1 of the First Protocol. And we'll come back to that in a moment. There are other things, though, that are sometimes relevant to the Scottish land reform question, human rights concerns. They're not, I don't want to say they're not as important as the European Convention of Human Rights, because clearly other human rights instruments are important. But then again, when it comes to Scotland, it's only the ECHR that's part of our lawmaking setup. The ECHR is embedded in what the Scotland Act says. So when it comes to the International Covenant on Economic, Social and Cultural Rights, which says people are entitled to housing, shelter and that kind of thing, that's important, sure, but it's not within what governs the Scottish Parliament. Okay, so not going to talk about tenure reform in terms of how people hold land technically. That's something we did reform in 2000. We passed something called the Abolition of Feudal Tenure, etc., Scotland Act 2000, which I'll say nothing about that. What I will talk about, though, are the ways that we've looked at changing how land is held in a non-technical tenure sense of ownership. And that went very quickly. Let's try that again. The 2 ways Scotland has tried to facilitate a redistribution of land from one existing owner to a new owner is there's been situations where a tenant has been entitled to buy out their landlord's interest, and this has happened in relation to some types of rural lease. They've been granted a right of first refusal, that is to say, a right to acquire the land if it is put up for sale. So it's not a forced sale, it's a preemption, it's a right of first refusal, so the tenant would be able to, rather than get a new landlord, would have the chance to find the money to buy out the landlord's interest and no longer be a tenant. So that's happened with a couple of rural leases, some specialist rural leases, and it also happened a bit with our social housing stock, council housing, but that right has gone away of late in Scotland because of issues with pressures of housing stock. And then at the bottom, the innovation in Scotland, and it's a kind of accidental innovation, and I think this is where I hope my talk will be most interesting for you guys and also be interesting to hear what you think. We've introduced this system whereby a community, and I don't mean the municipality, like a Scandinavian commune or anything like that. I mean local people can associate together, 10 or so local people, provided they've got the support of local individuals to that. They can then form a juristic body, a juristic persona, and acquire land in certain circumstances from the existing owner. And let's think about how this works. In the 90s, there were a few non-statutory acquisitions where, particularly in the Highlands of Scotland, the island of Gia, the island of Egg, spelt E-I-G-G, nothing to do with the thing that you eat in the morning, fried, sunny side up. The island of Egg acquired, the community there acquired their old landlord's interest, and they got some funding from local charity groups and also some money from a mystery benefactor. They were given a donation to purchase their land. And Egg and Gia and also there's a place in the West Highland, North Assynt, they essentially reacted to perceptions that they were being unfairly treated, and they wanted to look out for their land and take care of their land a little bit more than other people had been. So they became their own landlord, they became their own boss. And then the community movement in Scotland then influenced the then Conservative government to pass this Transfer of Crofting Estates Scotland Act 1997, which allowed the UK government, which at that point still had a few crofting holdings on its books, so they were still a local landowner in the Highlands, to transfer their land, to get it off their books and give it to a community. That legislation has only actually been used once in the Western Isles of Scotland, up at West Harris. But the real key influence of the Transfer of Crofting Estates Scotland Act 1997 is it really influenced the thinking of this land reform policy group, which was set up at around about the same time the Scotland Act 1998 was passed, to look at what the new Scottish Parliament might legislate for. And they thought, this community ownership, this seems quite good. We like this idea. We're going to go for community ownership. And their ideas about community ownership then found their way into the Land Reform Scotland Act 2003, giving communities a right to acquire land. And within this legislation is a nice comparator even within it. In Part 2, the way it was legislated for at first was rural communities, that was communities with a population of less than 10,000, were given a right of first refusal. This right, not as I say, to force a sale, but they could, if the land was exposed for sale, they would be the preferred bidder essentially, and they could take on that land from a local landowner. Then in Part 3, in certain crofting areas, you remember that map I showed with the blue areas of Scotland, the crofting areas, communities were given the right to acquire on a forced sale basis, an absolute right to buy, inverted commas, absolute. So they could force a sale from a private landowner for compensation. Obviously they'd still have to pay the price, and they would be entitled to buy the croft holding, the small tenanted area that they had, certain common grazings, which each township would have recourse to a common grazing with the way the crofting setup began in 1886, and some eligible additional land. So that's of more niche interest in terms of how many I think current statistics for how many people live in crofting households in Scotland, it's about 30,000 people. It's not many, but it's an interesting comparator for the Part 2 right of first refusal. Part 1 of the Land Reform Scotland Act 2003, that gave the right of responsible access to the outdoors, which is something else I've been researching lately. Okay, so should communities have this privileged position? Should they get this privileged position? And why are they getting that? Well, it's a very nice question. This chap, Alex Salmond, who was the first Minister of Scotland, speaking at the Community Land Scotland conference in 2013, came out with this idea that I think it's possible, and indeed I think it's necessary, for us to have a target of 1 million acres of Scotland in community land ownership by 2020. So we've got approximately 20 million acres in Scotland, so 5% of Scotland to be in community ownership. Recently, Scottish Government statistics have said we're at about 562,000 acres of community ownership, so we're sort of halfway there in relation to this target. In terms of where the million target came from, good question. Possibly just plucked a little bit from the sky, but I'm not criticising that because targets can be a good thing to work towards. In terms of how the Part 2 right of acquisition works, like I say, it allows communities to associate together to get a preemption, a right of first refusal. I've scored out the rural layer because in recent months, this right of first refusal has been extended to urban communities as well. So it's not just rural communities, it's also now urban communities. So, and that the first community to take advantage of that is a community in Edinburgh that's acquiring an old church in Portobello. I'm not sure if any of you know Edinburgh, but that's an interesting development. In terms of what a community must do, they've got to incorporate themselves as either a company limited by guarantee, a Scottish charitable incorporated organisation, or a community benefit society. So essentially they've got to become this non-natural person, and then that entity must have a suitably drafted constitution which says it's geared towards sustainable development, is locally accountable, all these kinds of things. Then they can register an interest in something called the Register of Community Interests in Land, and then when they do that, for a period of 5 years, the landowner must not sell the land without first offering it to the community. The community essentially interposes itself with a right of acquisition. The Localism Act in England came in a few years later. It doesn't give a right of first refusal, it just gives a right to bid. It's a slightly weaker right that they've got in England. So what the community can in that case, in the English example, they can associate together and they've got 6 months to find the money, and then they can make an offer to the landowner, and then the landowner can say, oh no, it's okay, I'd rather accept this other offer from someone else. The Scottish right is a little bit stronger. I should also say that the 2003 Act does not do anything to make a landowner who is a company entity. If the landowner was a company and it transfers shares in the company itself, this right does not bite. It's only a transfer of the land itself, so there are some avoidance mechanisms that can happen. In terms of how it works, I've already mentioned this idea that the community body must be geared towards sustainable development. When it comes to exercising the right, then a local ballot takes place, and also the Scottish ministers, so the civil servants, will then look at the overall scheme and say, is this in the public interest, and does it comply with the sustainable development? I'll come to sustainable development in a moment of the local area. And then, assuming it does, and assuming the local community is on side with it, then they will consent to the acquisition. It's not had a really marked effect in terms of numbers. There's been 20 or so activated rights to buy, but it's been important in terms of making communities get involved in the process and making landowners think about the local interests in the land that they might be transferring. Sustainable development is nowhere defined in the legislation. We don't define it, and that was a conscious decision. In the first couple of drafts of the legislation, they had a go at defining it, but then they thought, actually, no, we're going to take this out. We're not going to define it. So you're left with ideas. You're referring back to Brundtland. You're referring back to all these ideas of what sustainable development might mean. And then there's a nice question about whether it's right that only communities should be subjected to sustainable development type obligations. Maybe other landowners should be subjected to these obligations too. We'll come back to that in a moment. So in terms of how sustainable development looks, this seems to be the sweet spot in the middle there between environment, economic and social concerns. You're looking for something that satisfies all of those tick boxes, and then if the community can come together with that type of scheme, then the Scottish ministers will consent to an acquisition, provided it's also in the public interest. This is something else that's not defined in the legislation, and there was a bit of litigation about Part 3 of the Land Reform Scotland Act 2003, where the landowner said, this is all a bit vague. I don't like the fact sustainable development isn't defined. I don't like the fact public interest isn't defined either. But the court said, it's okay, we know what public interest means when we see it, basically, and it's a well-known term in terms of ECHR jurisprudence, so essentially it will be gauged at the time of each acquisition what is in the public interest. So where's Part 2 been ineffective? I'm going to give you two very quick examples. The Home Hill case was the first time litigation happened about Part 2 of the Land Reform Scotland Act 2003, and the local community, there was a perception that they were just trying to acquire the land for conservation purposes and essentially stopping a hotel development coming to pass. And there was this idea that they were thwarting development, stopping development happening. And it was decided that they shouldn't be allowed to proceed. And they were not able to use the Part 2 scheme. So sustainable development, it seems, implies development. There's got to be something. It's not just sustainable conservation, it's development that's important. And the example here of Loch Winnoch, this was an old bottling plant, the Crystal Clear bottling plant. I grew up in one village away from Loch Winnoch, actually. And what happened here was the community had mobilised to buy this asset that had a local ballot, but then the landowner decided, you know what, I don't want to sell. I'm just not going to sell anymore. And that was the landowner's prerogative. So it meant that when I went back last year and took a photo a few years after the abandoned site, essentially it wasn't looking so good, I took another photo, it's still not looking very pretty. There are new rights which might allow for the community to have stronger rights of acquisition that are on the statute books, which will be coming into force soon, and I'll tell you about them in a moment. I'm conscious of time. I'm going to accelerate through the next couple of slides. Part 3 is the crofting community right to buy, which, as I say, affects a relatively smaller area of Scotland, is not quite so important, but it's been used in a couple of situations to essentially encourage a landowner to go through with a voluntary sale. Voluntary inverted commas, because they know in the background there is a compulsory power that will force the sale to the local community. And as I've said, this did survive a challenge on European Convention on Human Rights ground when the landowner said this is an interference with my peaceful enjoyment. The court said, no, this is allowed, this is within the state's margin of appreciation to pursue this social interest of redistribution. And in terms of some of the non-statutory acquisitions that have happened historically, just to gauge how they've been working, these 3 renewable energy turbines are in the Isle of Gia, another photo that my friend took actually when we went over to Gia to visit. And there was a report a couple of years ago that Gia was really struggling in terms of debt. It had millions of pounds worth of debt and was seen as possibly an example of community ownership, was not something that was working. The issue perhaps with the scheme that we've set up for Scottish communities is that they own the land, but they can't sort of use that land for security or transfer off that land without undermining their own community purposes. So we need to think maybe more about how to have a model that works in terms of financing these communities. But I should say that's the sort of devil's advocacy position. The landowners, the community landowners of Gia say there was absolutely no problem. Their population had gone above 100. They've got new developments, new renewable energy projects and new fuel pumps and these kinds of things. So the community, in their view, is doing very well. In terms of the future reforms then, there's this new legislation, the Community Empowerment Scotland Act 2015, which introduces a power for communities to buy wholly or mainly abandoned or neglected land, and that's what the legislation says. It's a nice question about what is meant by abandoned. I don't think it means strictly dereliction in the sense of giving up an asset and trying to not be owner of it anymore. from government. It's a non-parliamentary departmental body, and it can try and steer what will happen in terms of Scotland's land policy, and it's been engaged with some research already, and I'm part of a team that's looking at what other jurisdictions have done to intervene in their land market to see what Scotland can do that might or might not be of benefit to it in its own reform programme. So what next for land reform? Well, we're still focusing a lot in Scotland on the idea that it's communities of place that matter, and all of our land reform steps are very much geared towards the idea that a community that's on the ground can benefit from this right. It's not about giving new communities or settling people on land that doesn't have a community at the moment. Which is about 50 miles from Aberdeen. This is another photo I took of an old abandoned farmhouse. Are they more concerned about just using it for recreation and going for a nice walk in the countryside? And that's covered in Part 1 of the Land Reform Scotland 2003. And then also you get the fact that land law reform is only part of a wider play that's going on in society. So we've got rural depopulation issues in Scotland, and I think it's Landflucht it's called here. So this is we've got to contend with this. We've got to contend with commodity prices being an issue in the agricultural sector. Land reform measures might not be the magic wand to fix everything, so it's all part of a bigger picture. And then in terms of further reading, there's a few resources there. The Land Reform Review Group, they've got a final report that came out in 2014. It's worth a look if you want to get a good handle on all the issues that still prevail to a certain extent in contemporary Scotland, and I declare an interest. I was an advisor to that. You can find various Scottish Government guidance and also look at what the new Land Commission is saying. And that's me. I hope that's been of interest. Thank you.
Thank you very much, Malcolm, and now we have time for our discussion. So who would like to start?